Ready? Although I join in the court's opinion in this case, the importance of the question impels me to add a word. The problem is not an easy one, and I do not think that inquiry can stop with a literal reading of the terms of the statute, plain though they may appear to be, taking, as I think we should, Section 2674 within the wider context of the purpose of the Tort Claims Act as a whole. I am still not convinced that Congress intended the $20,000 limitation in the Massachusetts punitive statute to apply to recoveries under the Tort Claims Act. In applying that limitation, the underlying reasoning of the Court of Appeals was that Section 2674 must not be read as subverting the overriding philosophy of the Tort Claims Act, that is, that the government should be liable in the same manner and to the same extent as a private individual under state law would be liable. It therefore argued that although Section 2674 departed from this philosophy when it made recovery compensatory rather than punitive in instances where the state remedy was punitive, the section in every other respect should be construed harmoniously with this philosophy, and that therefore maxima in state statutes should apply to recoveries against the government as well as private individuals, even though such a statute is punitive. It seems to me that the whole purpose and reason for the enactment of 2674 was to differentiate between the government and private defendants in the manner and extent of recovery in the particular cases where it applied, and I can find no good reason for giving the section only partial effect. In no case in Alabama or Massachusetts will a plaintiff recover from the government in the same manner as he would against an individual defendant, and in no case except by fortuitous circumstance will he recover to the same extent. In both of these states, if a highly culpable defendant causes small pecuniary injury, he will be punished at a high figure, whereas the government will merely pay the small amount of compensation. Or if a merely careless defendant causes high pecuniary damage, he is punished at a low figure under state law, while the government must pay for the heavy damage done. In both cases, the effect of the statute is to make the government liable in a different manner and to a different extent than a private individual under the same circumstances. This indeed was the very purpose of the amendment. I therefore do not see why this purposeful differentiation in manner and extent of recovery should stop at the problem of maximum recovery. Since the government is, by the very statute, made liable on a different basis than a private individual and will, in every case, pay a different amount than would a private individual, why does it offend the philosophy of the Act to make the government liable for more than a private individual would pay? Thus, while it is true that in general the Tort Claims Act makes the United States pro tanto a private defendant, the very purpose of Section 2674 was to prevent this assimilation in states where recovery is punitive. It seems to me, therefore, there is no reason to reestablish the assimilation on this one matter. Furthermore, I find it unlikely that Congress would have intended to subject plaintiffs to a maximum which was established for reasons of policy irrelevant to litigation under the Tort Claims Act. Massachusetts has decided that for reasons of policy and because of the danger of excessive jury verdicts in punitive cases, recovery under its punitive statute should be limited to $20,000. The statute being penal, it embodies the judgment of the legislature that the highest punishment that should be imposed for non-homicidal death is this figure. However, as soon as punishment has nothing to do with the lawsuit, and as soon as recovery is for compensation of the victim rather than punishment, then the policy reasons on which the $20,000 limit are based vanish. Massachusetts might, of course, impose a limit on compensatory recoveries as well. It did so for a short time, but then repealed the statute. It is clear that the limit embodied in this statute has nothing to do with compensatory suit. The factors which led to the imposition of this maximum are irrelevant when damages are not punitive. It would therefore seem to me just as artificial to take the $20,000 limit of this statute and impose it on a Tort Claims Act recovery as it would be to use as a limit a maximum figure taken from the state criminal statute imposing a fine for negligent homicide. The limitation in the Massachusetts penal statute was arrived at under penal concepts and should not be artificially imposed on a recovery from which penal considerations have been eliminated by congressional mandate. The Court of Appeals suggests that if the Massachusetts punitive maximum were not applicable, the government would be put at a unique disadvantage in that state, since the death statutes of some 12 other states place limitations on recovery which conceitedly would be applicable to the United States under the provisions of the Tort Claims Act. However, the limitations in these other states all relate to compensation statutes, and I do not, of course, suggest that such a limitation in Massachusetts would not also apply to the government. Okay, so from the bottom, go up 1, 2, 3 dollar amounts of $20,000. In other words, that's what you're looking for. So third from the bottom. So go from the bottom and you should have $20,000 3 times. On the third one up from the bottom, stop. That's where we're going to find that place first. Did you find it? In the, you mean the sentence?
Yeah.
Yeah. Yep. Anybody else there? You found it, okay. So if you go up from the bottom, you should be counting 1, 2, 3 $20,000 amounts. Yep. Yep. The sentence starts with Massachusetts has decided that, and it ends with that $20,000. That sentence ends with that. Find it? Emma, have you found it yet? Yes?
My notes are like jokes, so.
How about you, Nia? Did you find it? Okay, what's it? What do you have in the sentence so that we can see if you're in the right place? Yes, to $20,000. Yep. Okay, so from that point on, the next word is the statute. After she said that, she read the end of the sentence, which was 20,000. And then the next sentence is the statute being, okay? All right, Diana?
Okay, the statute being, is this embodied?
The statute being penal, it embodies.
Okay, that's fine. It embodies, is that
the judgment of the legislature, that the
highest punishment?
right.
Okay, that should be imposed for
non
I have non-dog.
homicidal.
Then is this dispute, is this figure, however, as soon as punishment has nothing to do with the lawsuit, and as soon as recovery is for compensation of the victim rather than punishment, then the policy reasons on which the $20,000 limit are based.
Okay, Leslie?
Might,
Massachusetts might,
of course.
of course,
Massachusetts might, of course, impose a limit on compensatories as well.
recoveries as well.
Oh, compensatory recoveries as well. It did so far a short time.
It did so for a short time.
Oh, it did so for a short time, but then, I don't know, repeal the statute.
Right.
It is clear that the limit employed,
Embodied.
embodied, and I dropped it, I'm assuming.
And where are you?
Employed has nothing.
Oh, in this statute has nothing.
With compensatory suit.
With a compensatory suit.
Factors which led to the imposition of this I even dropped it in there of much.
Maximum are irrelevant.
When
Damages.
damages are not punitive.
Okay, Natasha?
It would therefore seem to me just as artificial to take the $20,000 limit of this statute and impose it on tort claims act.
Tort Claims Act.
Recovery was
As it would be.
as it would be to use as a limit. Is it with
A maximum figure
maximum figure
taken from
the state criminal statute,
a state criminal statute.
imposing a fine for negligent homicide.
Okay, Emma?
Limitation is in Massachusetts,
In the
in the
Massachusetts.
okay, Massachusetts. Something saw was,
Penal statute.
okay, was arrived at under penal concepts and should not be officially imposed
Artificially imposed
as a recovery
on a recovery.
from which penal sections
Considerations
have been a limitation
eliminated.
eliminated by Congress, mandate the court
Congressional mandate, period. The court.
of appeals suggests that if the
Massachusetts.
punitive maximum were not applicable, the government should be
Would be.
would be put at a
unique
a unique discount
disadvantage
and in the state
in that state. Okay, and then I'm going to have Nia pick up there in that state since
Since the statute of some 12 other states place limitations on recovery, which conceivably would be applicable to the United States under the provision of the Tort Claims Act. However, the limitations in the other states all related to compensation statute and
statutes.
statutes. And I do not suggest,
I do not, of course, suggest
that such a limitation in Massachusetts would not also apply to the government.
Okay. Whew. That's a toughie. All right, let's do another street matter. Okay, ready? For the record, the petitioner is under sentence of death for murder in the first degree imposed by a California Superior Court and affirmed by the state Supreme Court. The validity of that sentence is not challenged here, but the California Penal Code provides that a person cannot be tried, convicted, or punished for a public offense while he is insane. Thus, if the petitioner is insane, California law prohibits his execution under the sentence which he received. The legal questions here relate to the procedures adopted by California to determine whether petitioner is sane or insane as a matter of fact. It is petitioner's contention that though he has been pronounced insane in a judicial proceeding after his conviction, and though he in fact is still insane, he is about to be executed because a state doctor has declared him restored to sanity. The doctor reached his determination without notice or hearings and without any opportunity for the petitioner to obtain an original court hearing and judgment of his sanity, or even to obtain a court review of the doctor's conclusion that he is sane. This procedure, it is argued, constitutes a denial to petitioner of that due process of law guaranteed him by the 14th Amendment. This claim was urged upon the California Supreme Court in a habeas corpus proceeding. That court considered the petition, but with two judges dissenting, denied relief and sustained the power of the state's executive agents to follow the prescribed statutory procedures. We granted certiorari because of the serious nature of the due process claims presented in the petition. Here, the California Attorney General, while supporting the state Supreme Court's denial of habeas corpus, asserts that California gives petitioner an adequate remedy by a procedure which has not yet been sought. The California procedure may perhaps be better understood by explaining the application of the controlling California law to petitioner's case. While he was in prison awaiting execution of the death sentence, a question arose concerning his sanity at the time. The state penal code prescribes that if there is good reason to believe that a defendant under sentence of death has become insane, the warden must call such fact to the attention of the district attorney. It is the district attorney's duty immediately to start proceedings in an appropriate trial court to determine the sanity of the defendant, and the court must summon a jury of 12 to hear such an inquiry. In petitioner's case, this course was followed, a judicial hearing was held, and he was determined to be insane. The court then ordered that petitioner be taken to a state hospital for the insane and be kept there in safe confinement until his reason was restored. It will be noted that petitioner obtained a judicial hearing as to sanity only because the warden started the proceedings. Thus, the opportunity for a person under sentence of death to have a hearing before a judge and jury on the question of his sanity depends solely on the warden. After judgment of insanity, the petitioner was taken to a state hospital for the insane in compliance with the trial court's order of commitment. The warden then suspended the death sentence and delivered certified copies of the court's order to the governor and to the medical superintendent of the state hospital to which petitioner was sent. The superintendent was directed that when the petitioner recovers his reason, the superintendent must certify that fact to the governor, who is then required to issue to the warden his warrant appointing a day for the execution of the judgment. The warden then returns the defendant to the state prison pending the execution of judgment. This course was followed with reference to the petitioner. 18 days after his admission to the state hospital, the medical superintendent certified to the governor that the petitioner was sane. He was returned to the custody of the prison warden, and the governor set a new date for his execution. The examiner's determination of sanity was based on his own investigation without notice of hearings afforded the petitioner or any person on his behalf. It is thus clear that the California statute challenged here provides neither an administrative nor judicial hearing as a prerequisite to determining that a condemned person who was judged insane has been restored to sanity. One man in an investigation decides the question of a defendant's life in the absence of a later request by the prison warden for a hearing. Started at 190, 200, 210. Okay, let's do some congressional warm-up.